Hello and welcome back. So this time we'll talk about contracts. All right, so let's begin. So what are contracts? So a contract is a meeting of the minds with respect to the other to give something or to render some service. Now the keywords in this definition are meeting of the minds. Of course, you have the parties, and of course, there is an obligation. So meeting of the minds is of course an agreement. This is the concurrence of the offer and the acceptance. Now, parties are, of course, the creditor and the debtor, the obligee and the obligor. Okay, now, as far as the obligation are concerned, so of course, we refer to either the obligation to give something or to render some service. So what are the elements of a contract? You have consent, the object, and the cause. Okay, now the consent, of course, is, as we have said, the meeting of the minds. The object here is either a thing or a service, and the cause here is the reason for entering into the contract. Now, what are the types of contracts? You have real contracts. Now, this classification or this typification of contracts is, of course, based on the perfection of the contract. So a contract may be real, consensual, or solemn. It is a real contract if it is perfected upon the delivery of the thing. It is consensual if it is perfected upon the perfection of the contract. And it is a solemn or formal contract if it is perfected upon the execution of the proper form. Okay, now the characteristics of contracts are relativity, obligatoriness, mutuality, and autonomy. So let's discuss them separately. So when you say obligatoriness, the contract is number one, the law between the parties and must be complied with in good faith. Now, for autonomy of contracts, the contracting parties may establish such stipulations, clauses, terms and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So there, Article 1306. Now, mutuality of contracts simply means that the contracts bind all parties, and the validity and compliance of contracts cannot be left to the will of one of the parties. And this is the reason why potestative conditions or potestative obligations are void. All right. Now, with respect to relativity, it simply says that contracts take effect only between the parties, their assigns or the persons to whom the contract or rights and obligations are transferred, and their heirs or the persons who will inherit in case of death of the parties. Now we have this concept of stipulation por autrui under Article 1311, paragraph 2 of the Civil Code. The requirements of a valid stipulation por autrui or a stipulation in favor of a third person are: number one, the contract contains a stipulation in favor of a third person. Next, the stipulation in favor of third person must be only part and not the whole of the contract because it is supposed to be an accidental stipulation. No? Next is that the contracting parties clearly and deliberately conferred a favor upon a third person and not merely incidental benefit or interest. Next, the favorable stipulation must be not compensated by any obligation. The third person must communicate his acceptance to the obligor before its revocation, and the contracting parties are not legal representatives or duly authorized by the third person to enter into the contract that gives the latter benefit. Otherwise, that third person becomes a direct party to that contract. Now, while we are talking about stipulation por autrui, where a stipulation is in favor of a third person, meaning to say the parties in that contract make a stipulation or extend a benefit, deliberately extend a benefit in favor of a third person, there is also a situation where a third person may be involved. And this is what we call the tortious interference under Article 1314 of the Civil Code. But take note, in tortious interference, the third person interferes with a contract entered by the contracting parties. So what are the requisites of a tortious interference? So the existence of a valid contract, the third person must be aware of the existence of that valid contract, and the third person interferes without legal justification or excuse. So let's look at this illustration. So there is tortious interference when a third person induces a manufacturer or supplier to revoke its exclusive distributorship agreement with another so as to enter into a new distributorship with the former. Okay, so that was the case in Excellent Essentials versus Extra Excel. Now, the remedy in case of tortious interference is action for damages filed by a party to a contract against the stranger or third person. Now, let's further compare tortious interference or the remedy against a tortious interference with what we call the action pauliana. So what is action pauliana? It is an action to rescind a contract entered in fraud of creditors. So it is initiated by a stranger or third person against parties to a contract. So this is not a tortious interference because this is an action this is an action recognized by law made by a defrauded creditor. Okay, so what are the requisites? The plaintiff asking for rescission has a credit prior to the alienation, although demandable. That the debtor has made a subsequent contract conveying a patrimonial benefit to a third person. The creditor has no other legal remedy to satisfy his claim but would benefit by rescission of the conveyance to the third person, that the act being imputed is fraudulent, and the third person who received the property conveyed, if by owner's title, has been accomplice in the fraud. Okay, so let's point out that because of the last element of action Poliana, an action Poliana may not prosper if the third person is an innocent purchaser for value. So what the defrauded creditor can do is ask for or file a claim and demand damages against the debtor who entered into that contract with the third person. Okay, now about the consent. So remember, offer and acceptance. An offer is a manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it. Okay. Okay, now meanwhile, acceptance means signification of conformity with all the terms of the offer. The acceptance must be unqualified and unconditional. Okay, there is no perfected contract if the offeree will not accept, but and will just make a counter offer. If the acceptance is qualified, the same is considered a counter offer, and the original offerer must accept the new offer, or mean to say the counter offer. Now, what are the vices of consent? Okay, take note of these vices because, of course, with these vices, the action is void. The contract is voidable. So, mistake. As far as mistake is concerned, it should be mistake as to the thing, conditions, or the identity of a party. Okay. Now, with respect to intimidation, this is reasonable fear of an impending and grave evil. It is a moral fear. Violence, on the other hand, is serious or irresistible force. So this is a physical fear. Now, undue influence is improper advantage of power over the will of another. And fraud refers to deception, insidious machinations, and manipulations. So if these vices of consent are present and if they affected or induced the party, okay, or a party to the contract uh, in enter into the contract, then that contract is voidable. Now, about the object must be within the commerce of man. So things and services are outside the commerce of man if they cannot be appropriated or they are incapable of private ownership or if they are intransmissible. But if they can be appropriated, they are transmissible, then the object is within the commerce of man. Now, the object must also be licit and not contrary to law, morals, good customs, etc. Now, to better understand it, of course, you just have to remember the examples, no? Uh, the moon and the stars are not within the commerce of man because they cannot be owned. On the other hand, drugs generally are licit, but if specific drugs are declared as illegal or illicit, then these drugs cannot be the subject of a contract because they are illicit. Okay, now with respect to service or the obligation to rent to do something or to perform something, then that object must not be impossible. In other words, it must be physically, legally, and practically possible. Also, the object must be determinate or at least determinable. The thing must be determined as to its kind and quantity. The thing is also determinable if the same can be determined without the need to enter into an agreement. Now, about the cause or the reason for entering into the contract must exist at the time of the contract. It must also be licit or lawful, and it must be true. For every contract or every special contract, every party thereto has a presumed cause or reason for entering into the contract. For example, in a contract of sale, the buyer's cause is to acquire ownership of the thing. Okay, in a contract of, let's say, comodatum, the bailey, uh, the bailey has a cause in the contract, and that is to borrow, use, and enjoy the thing temporarily. No? Now, if that cause does not exist, then therefore the contract is simulated, then the contract is void for lack of a true cause. Okay, next, form of contracts. Okay, now when we speak of form of contracts, remember the triumvirate of codal provisions. You have Article 1356, 1358, and 1403, number 2. So we'll start with 1356. And Article 1356 of the Civil Code provides that contracts are valid in whatever form, except that when the form is indispensable for its validity, then that form should be complied with. But take note that the form may be required, but only for convenience, such as in the case of Article 1358. So here, according to Article 1358, the following contracts must be in a public instrument. But the Supreme Court has ruled that this Article 1358 is only for convenience of the parties. So what are these contracts that must be in a public instrument? So number one, contracts involving real rights over immovable property, sale of real property or any interest therein, cession, repudiation, or renunciation of hereditary rights or those of the conjugal partnership of gains. Of course, this should include also absolute community of property, also power to administer property, power that may prejudice a third person, and cession of actions or rights proceeding from an act appearing in a public document. Now, take note that since this is a positive law, it can be a basis of action. Now, this is actionable. So a party to the contract may demand the other party to execute a public instrument, no? Because it is a right, it can be demanded. Now, let's talk about reformation of instruments. So when is reformation proper? So number one, there must have been a meeting of minds of the parties to the contract. In other words, it is valid, no, on its face. Now, the true intention of the parties, however, is not expressed. Now, this failure to express the true intention of the parties is due to mistake, fraud, inequitable conduct, or accident. So example of a contract that can be reformed is, let's say, a sale with right of repurchase is actually an equitable mortgage, no? Because the seller in that contract never intended to convey title or ownership of the property, but only intended to give the property as a security for a loan. So that contract of sale with right of repurchase may be reformed to make it or to convert it into a deed of real estate mortgage. Okay. Now, in the following contracts, reformation of instruments is not proper. So donations inter vivos, wherein no condition is imposed. Okay, also wills, and when the real agreement is void, because the court cannot order the reformation of these instruments and make or substitute, no, its own judgment or the judgment of the parties, no, to that which was originally stated in the original instrument. All right, now what are the rules for interpretation of contracts? So first, if the terms are clear and unambiguous, the literal meaning of the terms used is the controlling factor. So the verbal lehis rule, which we apply in the statutory construction, that is also applicable in the interpretation of contracts. Next, if the meaning of the words is contrary to the evident intent, then the evident intent prevails. So spirit will prevail over the letter of the contract. Now, also, the contemporaneous or subsequent acts of the parties may be considered, no? Especially in interpreting the clauses and the provisions of the contract. Now, when there is a conflict between a general provision and a particular provision, the particular or specific provision prevails. Now, let's talk about contracts of adhesion. Okay, one in which one of the parties imposes a ready-made form of contract which the other party may accept or reject, but which the latter cannot modify. One party prepares the stipulation of the contract while the other party merely affixes his signature or his adhesion thereto, giving no room for negotiation and depriving the latter of the opportunity to bargain on self-footing. Okay, take note that contracts of adhesion are not invalid per se. Also, in case of contracts of adhesion, the terms of which or the terms thereof must be interpreted and enforced stringently or strictly against the party which prepared the contract. All right, now let's look at a case. Now this is a Leonin case. So Gamon Philippines was awarded the project to perform the concrete works of the podium structure of the MRT3 EDSA North Triangle Station. Parsons Interpro JV was the management team authorized by the Metro Rail Transit Development Corporation, or MRTDC, to oversee the construction's execution. Parsons issued 3 notices to proceed to Gamon Philippines. The later notices amending the previous ones due to modifications or requests by MRTDC. Meanwhile, Gamon Philippines had started the design work, engineering services, dewatering, and cleanup. Later, MRTDC sent a 4th notice to proceed, which was different from those of the previous notices to proceed. When Gamon Philippines submitted a qualified acceptance, MRTDC said that it was a new offer from Gamon Philippines, for which reason MRTDC will award the project to Philsystems, a third party. So because of this, Gamon Philippines filed a claim with the Construction Industry Arbitration Commission, or SIAC, for MRTDC to pay the total amount of more than 58 million pesos. The SIAC, then later the Court of Appeals, decided in favor of Gamon Philippines. In this appeal, MRTDC claimed that there was no perfected contract between MRTDC and Gamon Philippines. So the issue is whether there was a perfected contract between MRTDC and Gamon Philippines. So the ruling was that the Supreme Court held that in bidding contracts, the award of the contract to the bidder is an acceptance of the bidder's offer. Its effect is to perfect a contract between the bidder and the contractor upon notice of the award to the bidder. MRT has already awarded the contract to Gamon, and Gamon's acceptance of the award was communicated to MRT before MRT rescinded the contract. In this case, the 2nd, 3rd, and 4th notices did not have the effect of canceling the 1st notice to proceed. If at all, the 1st notice to proceed was only suspended or modified by the subsequent ones. But just the same, the contract is already valid, binding, and effective. That's Metro Rail versus Gamon Philippines, decided January 17, 2018. All right, now let's look at defective contracts. So you have the void or inexistent contracts, the rescissible contracts, the voidable contracts, and the unenforceable contracts. So let's first look at the void and inexistent contracts. So void and inexistent contracts are generally those where one of the essential requisites of a valid contract is totally wanting or totally absent. Again, the elements are consent, object, and the cause. Now, absence of any of these elements will render the contract void. So a void contract produces no legal effect. It cannot also be ratified. Now, the right to set it up is also imprescriptible. So it can be raised anytime. Now, the action to declare the nullity of a contract also does not prescribe. Now, generally, courts will leave the parties as they are, following the in pari delicto rule. Of course, don't forget the exception. The exception is that when the parties will be left where they are, it will result to a violation of a public policy. No? Okay. You want an example? Where example would be that a contract entered between a foreigner and a Filipino for the purchase of a property, a real property in the Philippines, and let's say the foreigner was in possession of the property. The court will not apply the in pari delicto rule, because in that case, the foreigner will be allowed to keep the property, which is exactly what is prohibited by our Constitution. So the parties will be allowed or will be ordered to restitute what they had what they had received from each other. The property will be returned to the foreigner, to the Filipino, and the purchase price will be returned to the foreigner. Okay, now let's talk about voidable contracts. So generally, those where one of the parties is incapable, okay, of giving consent. Okay, meaning minor, insane person, what else? A person is deaf mute. Ayan. So only one party is incapable of giving consent. Also, where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Now, the action to annul a contract may be lost due to prescription, 4 years, because the action should be filed within 4 years. Now, also, the petition or the action for annulment may also be denied or dismissed because of ratification by the injured party. Okay, so how does a minor ratify the contract? How does an insane person ratify a contract? How does, for example, an imbecile or a deaf mute ratify the contract? Well, this contract can be ratified by their guardians. These persons can also ratify this themselves if they have acquired capacity. For example, in the case of a minor, when he reaches stage of majority, or in case of an insane person during his lucid interval. All right, now rescissible contracts are contracts, although validly agreed upon, which can be rescinded by reason of lesion or economic prejudice. Also, remember that lesion is the injury suffered by one who does not receive a full equivalent for what he gives in a commutative contract. Now, this is very brief, but I hope you will remember rescissible contracts under Article 1381 is different from rescission of contracts under Article 1191, as explained in the case of Welex Group versus okay, there's this Taiwanese U-land, ayan. So U-land, okay, U-land, okay. So in the case of Welex versus U-land, the Supreme Court explained the difference between Article 1191 and Article 1381. 1191 is based on a breach of an obligation. Article 31 is based on a defect in the contract. Article 1191 can only be filed by a party to the case, but Article 1381, the action for rescission under Article 1381, may also be filed by a third person like a creditor. Thus, we mentioned earlier, Accion pauliana. Accion pauliana actually falls under rescissible contracts under Article 1381. Okay. Ayan na pala. Andiyan na pala. Okay, sorry po. I failed to see that. All right. So that's the difference between Article 1191 and Article 1381. Okay. Now, notes on rescission. Rescission creates the obligation to return the things which were the object of the contract, together with their fruits and the price with its interest. He who demands rescission must be able to return whatever he may be obliged to restore. Now, the action for rescission is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same, like suing for specific performance, or let's say reimbursement or payment in the form of damages. Ayan. Now, the action for rescission must be commenced within 4 years. All right, so this is a Leonan case. This is the case of Welex Group versus U-land. So I will not discuss that anymore. So let's now look at unenforceable contracts. So what are these unenforceable contracts? So these are those contracts which are entered into in the name of another by one without or acting in excess of authority, meaning agents. Okay, so those entered into by agents, okay, whether that agency is established or not. Now, if it is established, but the agent exceeded his authority, then that the contract entered into by that agent is also unenforceable. Also, if there is no agency and this person pretended that he was an agent, therefore he had no authority, then the contract entered into by that fake agent is, of course, unenforceable. Also, we have that situation where both parties are incapable of giving consent. So remember earlier we said that if only one of the parties is incapable of giving consent, then the contract is voidable. And lastly, those which do not comply with the statute of frauds. Now, as I've said earlier, there is this triumvirate as to the form of contracts, Article 1356, 1358, and 1403, number 2. Okay, so Article 1403, number 2, is the Statute of Frauds. And under the Statute of Frauds, the following agreements should be in writing. So first, agreements not to be performed within a year from the making thereof. Also, special promise to answer for a debt, default, or miscarriage of another, like a contract of guarantee. The agreement in consideration of marriage, other than a mutual promise to marry, for example, a marriage settlement. Also, agreement for the sale of goods, etc. Okay, for a price not less than 500 pesos should be in writing. So 500 pesos and 1 peso, or 500 peso and 1 cent should already be in writing. Also, contracts of lease for a period longer than 1 year. So if the contract of lease is less than 1 year, is for a period less than 1 year, then it need not be in writing. Okay, now agreements for the sale of real property or interest therein should be in writing. Although under Article 1358, it should also be in a public instrument. Also, representation as to the credit of a third person is also required to be in writing. Now, note that the statute of frauds requires that the contract be evidenced by some note, memorandum, or any writing. Also, the statute of frauds applies only to executory contracts. These have been contracts that are yet to be executed. So it does not apply to partially or fully executed contracts. Okay, so the contracts supposedly covered by the statute of frauds become enforceable when they are ratified. So ratification or retention of benefits, okay, is a or ulitin ko, ratification by confirmation of the contract or by retention of benefits, okay, will take the contract out of the statute of frauds. All right, let's look at this case or problem. So AR Properties as buyer and TL Realty as seller verbally agreed for the purchase of TL Realty's building constructed on XY Corporation's land for the price of 1.5 million pesos. AR and TL agreed that AR will make a down payment of 500,000 and then TL will prepare the deed of absolute sale and assignment of lease provided that XY Corporation will agree. Months passed, but TL failed to execute the deed of absolute sale and assignment of lease. Because of this, AR filed an action for the refund of the 500,000 pesos down payment. TL refused to pay, invoking the statute of frauds. Is the statute of frauds applicable? Explain your answer. Okay, so the answer is no, the statute of frauds does not apply. It is well settled that the statute of frauds is applicable only to executory contracts, not to contracts that are totally or partially performed. Also, it was ruled by the Supreme Court that an action by a withdrawing party to recover his partial payment of the consideration of a contract which is otherwise unenforceable under the statute of frauds by reason of the failure of the other contracting party to comply with this obligation is not covered by the statute of frauds. Hence, the verbal agreement was partially performed when AR Properties made a down payment of 500,000 pesos. Moreover, AR's action is for refund of the down payment. Hence, on those two grounds, okay, the contract entered between AR and TL is not covered by the statute of frauds. So those are your unenforceable contracts and the statute of frauds.